Zoning bylaw changes, right? I know everybody's dream at night is going home, reading the zoning bylaws, looking for minor clauses or variances that you can exploit. So just thought I'd make it a little easier for you and kind of lay out all the changes that have happened. But first I want to just thank you guys for your hard work, right? Landlording isn't an easy job. Right? Anyone who's done it for any period of time knows that they put up with a lot, and the pandemic has not made it any easier, right? The LTB backlogs, tenants losing their jobs, not being able to pay rent. Right, it's been a pretty tough go, so I just want to thank you all for being landlords and housing about 30% of the city. Right, a lot of people don't realize just the size of the tenant community, and that about 35% of Thunder Bay residents rely on you for their homes. So kind of thank you for being landlords to start. I also want to thank our sponsor for tonight, right, Jones & Associates and Hawkeye Home Inspections. So Jones & Associates, they're an amazing insurance brokerage. I use them for all my insurance needs. And they actually just took home a customer service award at the Chamber of Commerce Business Awards. So if you guys ever need service for your insurance needs, Jeff Jones and Jones & Associates are there to help. And Hawkeye Home Inspections. They're a new home inspection company in town, and I actually gave them a test drive myself this past week when I was looking at investment property. And they're very good, very thorough, and you'll hear from a little bit more from them tonight. So thank you for sponsoring the event. And I want to thank you all generally for trusting Rent Panda. Right, we started as a very small company here in Thunder Bay about 5 years ago, and we've grown quite a bit. We've launched across the province this past year, and hopefully we'll be going national within the next year or so. So, for me and my brother Hart, who's here filming, from us as founders, I want to thank you guys for supporting us. I don't know if we could have pulled this off in another city other than Thunder Bay, so thank you for your support. All right, so to jump into it, the story about zoning started way back in 2018. So this is a fun multi-year saga when the official plan was changed. So every 5 to 10 years or so, the city updates their official plans. And the official plan immediately triggered a review of the zoning bylaws. So this opened up at essentially a once-in-a-decade opportunity where the zoning bylaws fundamentally came up for review, and there was an opportunity for some more fundamental change. So starting off with that, knowing how zoning affects rental housing and how antiquated our zoning bylaws were, I teamed up with the Chamber of Commerce, and we put together a really comprehensive kind of citywide coalition to push the city to change the zoning bylaws. So we worked with organizations like East Coast Superior and Roots to Harvest and the Housing and Homeless Coalition and the Multicultural Center, and there were about 30 other organizations that joined us, Rent Panda, and the Chamber in really giving the city a big push forward and saying, zoning is something that's stuck in the past, and it needs to modernize to open up opportunities not only for people's housing, but also for business opportunities in the city. So from there, working with the Chamber, I wrote a white paper essentially on everything that zoning was supposed to do for the city. So a really big overhaul focusing on turning the city into a walkable, mixed-use, mixed-income area. So something that's really friendly to both housing, to both lifestyle, supporting the environment, the social connections we need in town, and pushing for some real fundamental change. So thankfully, the city listened to us, and in April of this year, it was kind of a little delayed by the pandemic by about 3 years, but in April, so just last month, the city actually passed a comprehensive review of all of their zoning bylaws, and everything changed. There is nothing that was formerly part of the zoning bylaws that is the same essentially as of today. It's going through the last stages of approval. So within a couple months, it'll essentially become reality, but they're already implementing the new zoning bylaws when they look at things like enforcement. So what that actually means in practice. It's a little bit small here, but if you actually look at the zoning bylaws online, these are all of the new categories. So everything has been fundamentally rewritten. All of the old categories no longer exist. There's no more R1, R2s, R3s. That doesn't exist anymore. Louder? Louder. All right. So the new categories that are most relevant to us are the urban neighborhood zones, and specifically the urban low-rise. Right, so the urban low-rise is where it's going to be the vast majority of properties that you guys are looking at is in this new urban low-rise category, which essentially encompasses about at least 95% of the residential land base in Thunder Bay. So let's look at some of the details of what this urban low-rise category actually means. So here's the definition from the zoning bylaw. So a lot of it is semi-technical language, And a lot of what you understand as common sense is not how zoning bylaws interpret what they mean. So for example, everything in the urban low-rise category is 2 stories or less. So even though apartments are allowed under the urban low-rise category, apartment is not what we understand as an apartment building. It means something else. All right, so it's important when you're looking through the zoning bylaws to kind of look through the definitions and to understand what you can and can't do by the category. So the normal stuff like detached houses, semi-detached houses, townhouses are kind of things you're familiar with. And one of the most fundamental changes is that now any residential property can have at least 2 units in it. Right? So all of those basement apartments that may have been, kind of questionably legal before are now de facto allowed under any urban low-rise zone. Right? Now, when we look at the other definitions, so an apartment under the urban low-rise category essentially means any residential building with 3 units or more. Right? So this doesn't mean if you have an urban low-rise zone, you can just build a 20-story apartment building because it says apartment. It has a very specific meaning, which is kind of 3 units or more that may share a common entrance, but essentially it's a number of units category. Right? So this is still anything 2 stories or less, but if it's 3 units or more, it counts as an apartment. Right? So the terminology is kind of important as you wade through all of the details of the zoning bylaw. The other thing that's pretty interesting is the converted house definition. So to a regular human, a converted house means a house that's been converted into something else. To the zoning bylaws, it basically means that it's a house that was built prior to January 1st, 1945, that used to be a single detached house and is now a multi-unit house effectively. So this category is interesting. I'll get into a little bit more detail later, but it essentially waives almost all of the requirements around frontage or lot area, any of the nitty-gritties of the zoning bylaw that can restrict how many units you have. So if you do have an older home that was built prior to 1945, you're likely eligible to be counted as a converted house, which means you can do almost whatever you want with it with an almost unlimited amount of units. So it's a pretty interesting category that if you start looking into kind of what zone you fall into and how old your house is, if it's pre-1945, you're playing kind of with a different set of rules, which generally benefit you to the expense of everything built after 1945. So when I talked with the planning department, this is essentially part of their efforts to densify the city. So the older the home is, the more likely it is to be in a kind of closer to the urban core. And that means that they want more density in the urban core, so they give you this kind of really big exemption that I'll get into in a minute. That's the converted house definition. So some of the details, as thrilling as they are, so if you're in a detached house, right? If you have 10 meters of frontage, you can qualify for 2 homes. So now what they used to call dwelling units, they now call homes. So homes or units basically interchangeable. So any house basically qualifies for 2, but if you have the right frontage, if you have 15 meters of frontage, you qualify for 3 units in a regular single detached house. Right? So that's a pretty significant evolution from what was previously, where if you had a single detached house, you could have 1 house or 1 unit, 1 home. Now, you basically automatically qualify for 2 and potentially up to 3, right, depending on how much frontage you have. Right? Height restrictions still apply, but some of the other categories you need to be aware of. So for the maximum number of homes, again, is the lot area. So basically you need 150 square meters of lot area per home, right, per unit. But again, if you have about 450 square meters of lot area, then you can qualify again for up to 3 units in a regular single detached home. Right? So again, if you have the right size property, you can do a lot with the density that's allowed under the new zoning bylaws. So this is, the details are relatively mundane, but it's a relatively radical shift in terms of what you can do with a property and how many units you can fit in it. Now this has really big potential for increasing the, that's better. That has huge potential for increasing the number of units you can put in. So for example, just crunching some general numbers, on a regular, single detached house in the city, let's say it was 3 bedrooms, you could probably charge $1,800 a month for it. But we found that, even if you split that house, if you had an unused basement, right, something that was maybe unfinished or kind of partially finished, maybe had an extra bedroom down there, Now that you're able to convert that basement into a separate unit that's now legal under zoning, you can basically go from cash flowing about $1,800 a month. With a basement conversion, a 3-bedroom house, main floor, will surprisingly rent for almost the same as a 3-bedroom full house. So with our property management division, we've actually rented 3-bedroom main floors for $1,800 a month. And then with the basement unit, you can add probably $900 or another $1,000 a month. So it's about a 44% increase in your cash flow, kind of with conservative numbers, that you can do just by adding one basement unit, right? You can kind of multiply that again if you have a regular 2-story house and you do a top unit, a main floor unit, and a basement unit, right? So if you have a decent sized lot with zoning, you don't need any exemptions. You can just build 3 units. You put your building permits in, that's all you need. And you can rent them out legally as a triplex, right? So you can get a huge jump in the number of units you can put in, relative to the old zoning bylaws. Now, all of this is separate from the new category of backyard homes. So backyard homes are considered an accessory use. So in zoning world, there's main uses, which is essentially your main building having your main number of homes in it. And then an accessory use can be this new thing called backyard homes. So there's kind of all the definitions of what fits into a backyard home. You need to be kind of on city sewer and water. You need to have a certain amount of setbacks and things like that. But essentially, again, if you have a decent sized lot, in theory, you can have 3 units in your main building, and you can build an additional backyard home in an unused back portion of the lot. So you can essentially have 4 homes on a regular plot of land that was formerly just a single detached home. Right? So you can, in theory, jump from being allowed 1 home to 4 if you have the right lot size. So it's a pretty radical shift in exactly what you can do and how much cash flow you can bring in for the property that you already own. Right? So this isn't necessarily kind of new builds, giant kind of plots of land in the rural areas. This is all within the urban core, and especially they're doing a big push to densify, the closer you get to the downtowns. Right? So this is a little map from the zoning bylaws again. All the details are in the actual zoning bylaw document available online. But you can see in the kind of far left side, you can have a regular, detached house here, and what was formerly backyard space, you can add an entirely separate backyard home as long as you have some basic things like 1.5 meters, between your side yard, 1.5 meters between your rear yard. But it opens up a lot of different options. And this is just for detached homes. If you have a townhouse, right, or a semi-detached, you're also allowed to build backyard homes on them. Right? So again, if you're just sitting there with unused grass that's basically costing you to mow, if you have the right dimensions, you can turn that grass into cash flowing properly by putting up a simple backyard house. Something like even like a shipping container house that some of the companies are building in town. You can kind of plop one of those down, and you've got another cash flowing property, and it's totally legal by the zoning. Now, if you have a little bit of a bigger plot of land on a zone that's called the urban mid-rise zone, so this is the next level up. So again, this has nothing really to do with the number of units, but specifically has to do with how tall the building is. So remember, the entire urban low-rise zone is everything up to 2 stories. If you have more than 2 stories, between 2 and 4, you may be in what's now called the urban mid-rise zone. All right, so this is intended for a little bit bigger properties on a little bit bigger plots of land. Generally, the minimum number of homes you're supposed to have is 5, so kind of 5 units in those. So definitely getting towards more something like a purpose-built apartment building. But again, if you have a bigger house or one of those older properties that used to have commercial spaces in it that's been converted and reconverted and converted again over the years, that may be a little bit of a separate category in the mixed-use category we'll talk about, or you may fall into the urban mid-rise. And this one, we're not going to kind of dwell on it a lot. The details are in the zoning bylaw, but again, just to be aware that there's these kind of separations based on height and not anymore really based on the number of units. So the next level up, we're not really going to touch on at all today, is the urban high-rise category. It's the last major kind of urban category that's basically more than 4 stories high. Right? So this is your generally bigger apartment buildings. There's not a lot of buildings in town that are more than 4 stories that are short. So this is kind of your Dawson Properties, Red River Towers. If you have a building that's big, you're probably going to want to seek more professional advice than what you're getting here today. But just know that that's another major category under the new bylaws. So the most interesting of all categories, if anybody actually has this zone, it's kind of the gold mine of zoning as the new zoning bylaws go. It's called urban mixed use. So this one is incredibly flexible. You can basically put whatever you want in it. You can put apartments, right? And apartment by the definition is 3 homes or more. So you can have 5 homes, 6 homes, 7 homes. There's not a lot of restrictions in the urban mixed use category. You can put office space, you can put retail, you can basically put whatever you want if your property is zoned urban mixed use. So this is kind of the golden ticket of property zones. Most of it is individually zoned, so there's not like swaths of the city that are zoned urban mixed use. So if you are a mixed use zone, you are probably the MU1 or MU2 under the old zoning, but know that it exists. And if you have a property that used to have some commercial into it and it was converted, like if it was one of those funky properties that was older, that changed over time, you may, if it isn't already, you may want to consider applying to get it formally zoned as urban mixed use, because once it's zoned urban mixed use, and once the city acknowledges that, it's kind of like a carte blanche to do almost whatever you want with the property. So it's a really neat kind of ticket in your back pocket if you have one of those. Now, part of why it's so good is there's essentially no limit on the maximum number of homes. So there's no limit. The only restriction is essentially lot area. So for every 125 square meters of lot area, you can add an additional home. So as long as your property is big enough, you can kind of jam as many rental units into that property in the mixed use category as you want. Right? You can see most of it, there's no minimums, like not a lot of maximums. So it's a really flexible area. The only big thing is just making sure that your total lot coverage is less than 40%. Right? The city doesn't like to see places just kind of paved over with concrete. That there's some green space for stormwater management and drainage and all that kind of stuff. But again, if you have an urban mixed-use zone, it's almost not quite unlimited, but essentially the sky's the limit on what you can actually do with it. Now, one thing that I didn't touch on here is that there's a big change in the parking restrictions. Right, so before, depending on what exactly your R designation was, there was a different amount of parking spots. Now they've roughly standardized it across all of the urban zones, and it's 1 per unit. Right, so it's no more like 1.5 or 2 or 1.75 or 1.25 or kind of all the weird math they used to do to try to figure out how many units and kind of what's the square root of X. It's just 1 per unit. Right, so that also radically limits how much parking you have to have, which is one of the main barriers that people had to actually converting. Right, if you had like a regular driveway, right, and it only fit 1 or 2 cars, and you wanted to put in additional 1 or 2 units, the parking was a big stumbling block. So now it's just 1 per unit. That's all you're required to have by zoning. You can have as much parking as you like, but it also radically simplifies things and allows you to greatly expand the number of units you have without zoning being the major hurdle. So here's an example of the actual new zoning bylaw map. Right? So you can see this is downtown Port Arthur. Here's Red River Road. Here's Algoma. Here's Court Street. Right? River Street's up here. So just as an example of how the city's actually mapped this on, it can be relatively dynamic. So you can see the categories here. The UL is the urban low-rise. So most of it is still urban low-rise. But then here's the urban mid-rise. This whole swath of the street is now urban mixed-use. Right? There's some the UX, the urban mixed-use categories. And then there's some of the categories we haven't talked about that are more commercial in nature, but the MS is Main Street, and here DN is downtown neighborhood. Right? So if you have any properties in any of the downtown areas, so on the north or south side of town, and you're in one of the Main Street or downtown neighborhood zones, this is even better than being essentially in an urban mixed-use zone, which is kind of the best you can get under the urban category, again, because it is so expansive in what you're allowed to do. So I'm not going to get into too much detail, but just for a teaser, the parking limitations are only 0.2 units or 0.2 parking spaces per unit. Right? So any of the urban zones, it's been reduced to 1. If you're in any of the Main Street or downtown neighborhood zones, it's only 0.2 parking per unit. There's also essentially an unlimited amount of units you can put in, and these have been zoned relatively generously. So a lot of regular single detached housing ended up falling into these zones. Because the city's trying to put a big push behind densification. So if you do end up having a property in this zone, just know that you can do a lot with it, right? You can put in any kind of commercial business you like in general, but also a relatively extreme amount of residential units compared to what you could before. Okay, so that's kind of the general overview of the details of the zoning. But one of the biggest things that people know the least about is committee of adjustment. So if you're looking through the zoning bylaws and you see, hey, I've actually only got 12 or 13 meters of frontage and not 15, but I wanted to put in the third unit, or I've only got 0.8 meters of setback to my rear line, but I still want to put in a backyard home. The committee of adjustment is a city committee that was created for the explicit purpose of approving exemptions. So the entire reason the committee of adjustment exists is to approve exemptions to the zoning bylaw. And I happen to know because I actually sit on this committee, so I'm one of the 5 people that essentially adjudicates all of the decisions that come before the committee of adjustment. And I can tell you it's a relatively easy process. So if you find that you want to do something and the new zoning bylaws are still a little bit too restrictive for you, basically never say no. There's always a way to get done what you need to get done, and the committee of adjustment is the easiest, most streamlined way you can do it. All you have to do, you don't need lawyers, you don't need any specialized knowledge, you don't need to hire anybody, you don't need special drafters or surveyors. You basically just need to go to the planning department, tell them what you want to do, they're going to tell you no, and then you tell them I want to go to the committee of adjustment, right? And then they'll go through a pre-consultation phase, which is essentially just saying, hey, are you sure you want to do this? And if you want to do this, here's where you're going to have to budge a little bit. And you say, yeah, I'm still assured, I want the exemption. And then you literally just go before a committee of 4 other people like myself, right? It's not city councilors, it's not judges, it's regular people appointed by the city to this tribunal to allow exemptions to the bylaws. And you present your case. You say, hey, I want to put in a backyard home. I only have half a meter of setback to my rear yard, but I'm in an area that I think the city would benefit from an extra backyard home. And we look at that and we go, yep, that sounds reasonable, approved. Right? It's really that simple. It's really not a complicated process. It's not intimidating. And we've approved some relatively radical things, like really big reductions in setbacks or lot area or frontage requirements, because the city has a mandate by the official plan to densify. There's certain targets that the city sets every year for how many new homes they want in the city to try to kind of combat the sprawl that's been happening. So the Committee of Adjustment essentially has a mandate to approve exemptions as long as they're anywhere within the realm of reasonable. And what counts as reasonable is basically people like myself saying, yep, that's reasonable. Okay? So it's really something that is heavily underutilized that I encourage you guys, if you're looking at something and it looks like it's a no, it's probably a yes as soon as you get to Committee of Adjustment. All right, so moving on a little bit, we're kind of moving a little bit past zoning. And since I have you all here, I wanted to give you an update on some of the things that have been happening at the Landlord-Tenant Board that have changed in a relatively significant way since the start of the pandemic. Right? So the kind of biggest thing is everything is digital now, right? There's no more faxes and submitting paperwork and mail and kind of waiting for them to call you back. Everything is working through this digital platform that the LTB has set up, and you actually kind of check in LTB time on the status of your submissions. So for example, through our property management company, we have a couple of people we're trying to evict now. It's not any faster than it was before, but at least you get up-to-date information through the online portal, and you can submit it in a much easier way than having to fax something in. I mean, I don't know about you, but I don't own a fax machine, so it was pretty painful before. So now you can just kind of upload it through the system. It works pretty smoothly. And if you've been lucky enough to not have to have evict a tenant over the last number of years, then just to be aware that essentially all of the LTB hearings are now done on Zoom. Right? So there's no more kind of going down to the Italian center and waiting there all day and hoping they call your case number. Essentially all done online right now. So it's much nicer. I mean, for me, it's kind of like my bookkeeping time where I'm waiting to be called and kind of sitting there, kind of pedaling around, and you can do other things. You can actually have a productive day while you're waiting for your LTB hearing. So that part is nice. All the regular procedures are relatively similar, but at least it's all done online now. So the other really big thing that works really nicely with the zoning bylaw exemption is the rent control exemptions that were put into place during the last round of legislation. So under the new legislation guidelines, any new buildings or new units, including new basement apartments or any unit that wasn't previously fully used as a separate residential unit, is not subject to rent control. Right? So everyone knows that normally you have a tenant move in, you set the rent at whatever you want, and then you're subject to the provincial guidelines every year, right? This year it was 1.2%, the year before it was 0, right? So like almost no rent increases in the last couple of years when we know, the water bill's going up, right? The power bills are going up, taxes are going up. You just couldn't raise the rents. So this is something that works really well together with the new zoning bylaws, that if you're putting in new units, none of those new units are subject to rent control. So every year you can raise the rent pretty much by whatever you want because it's exempt from the traditional rent control legislation, right? This could change depending on if the government changes, but currently, as the legislation stands, no new units are subject to rent control. Okay? So new units is anything that was not used for first-time residential purpose after November 15, 2018. So for example, if you had a house that had like an unfinished basement or a basement that wasn't being used as a separate unit, and then this year or last year or next year or kind of sometime in the future until the legislation changes, you convert that basement into a basement apartment, then it's considered a new unit. So this is where I would kind of encourage everyone to document carefully. So in case you get a challenge, right? In case you get a tenant who moves in, and then the year after, you're like, hey, your rent's going up by $100, and they say, no, where's my 1.2%? And they say, no, you're in a new unit, rent control doesn't apply, and they challenge you. Have your paperwork done ahead of time, because after the fact, it's almost impossible to prove. But if you're doing renovations, then take photos of before, take photos of after, keep the invoices from your contractors, anything that you can legally show and prove to the court that, yeah, this was like a concrete nothing, and now it's a residential unit, so this is a new unit, right? So it's pretty new. Not a lot of people have taken advantage of this, and especially in tandem with the zoning changes, there's kind of like a very unique double whammy that you get, that all of a sudden you can create new units, and none of those units are exempt or rent control applied. So it creates a really interesting window of opportunity in Thunder Bay specifically to really maximize the amount that you can generate from your rental properties.
Rich, is there any expectation of disclosure of a new unit?
Expectation of what?
Well, like if I'm a tenant going in, and the max I think that I would see as a rent increase would be 1.2%.
Right.
And then I get hit with a 20-30%. So there's no expectation to mention.
So one of the other really interesting things that came out of the last round of legislation was payment plans. So when you have a tenant that's not paying rent, right? Like let's say my tenant moved in, in April, and as of May they stopped paying rent, right? They're those fun tenants that give you first and last and rent never in between. Essentially what you have to do is you're not legally required to offer them a payment plan right off the bat, but it's heavily in your interest to offer them a payment plan. And the LTB has gone so far to create this lovely form for you to use. So you can go on the LTB's website and download the form, and it's essentially a pre-made payment plan form. Now, why it's good to offer your tenants a payment plan, you'd say, hey, my tenant's a deadbeat, they're not paying rent, like I don't want to give them an opportunity to kind of weasel their way out of this. But it's actually a really good opportunity to jump on because it's effectively the new standard when you go to the LTB, when you're trying to actually evict a tenant, and they want to know how reasonable you've been as a landlord. So one of the first things that they'll ask you when you go to the hearing is say, okay, here's the record of my tenant not paying rent, and they'll say, great, what kind of payment plan did you offer them? And if you say 0, I didn't bother, I don't care, they owe me rent, like that may be fine for you as a landlord, but the LTB, whose mandate is essentially to try to keep tenants in their homes, is going to say, well, hey, tenant, are you open to a payment plan? And if that tenant has half a brain to be like, oh yeah, I'm open to it, then the LTB will require you to have a payment plan, right? Or essentially try to enforce a payment plan on you if it's deemed reasonable. So if you do your kind of pre-homework and you offer them a payment plan ahead of time, you can say, yeah, like, you owe me X, right? You're going to pay me an extra X amount per month for the next 4 months until you catch up on full rent. And then we'll be square, right? All the rent will be paid, no one's behind, and you have to make it reasonable. So this is something that the Landlord Tenant Board will look at, that if it's deemed unreasonable, they're basically going to count it as if you didn't even try, right? If your tenant falls behind in 3 months of rent, and you say, okay, what's reasonable is you pay me all the rent you owe me plus next month's rent on the 1st of next month, right? Like no tenant is ever going to be able to make that up. So you have to be reasonable with your repayment plans. It may mean 6 months or a year of them paying back an extra $200 or $150 a month. You have to make it so they can actually do it. But if you offer them a plan and they reject it, you can take that essentially as evidence to the Landlord Tenant Board saying, yeah, I was an honest landlord. I did my best. I offered them a repayment plan. I tried to work with them. They're unreasonable tenants. Like they just refuse to pay. They refuse to work with me. So you're that much more likely to get a sympathetic ear from the adjudicator. The other Sorry, yeah? Yes, the question was about undue hardship. So you're talking about with like accessibility requirements? Yeah, so I would say it really depends on the details of the unit and kind of what's deemed reasonable. I'll say we do have our in-house paralegal here. Christine Stewart, who's sitting in the audience, is the Rent Panda paralegal. So if you do have really specific questions, especially around touchy subjects that are more gray, like undue hardship or kind of what's the reasonableness threshold, she'll stick around for a little bit and answer your specific questions after. And then I encourage you guys to kind of get in touch with her after if you do have paralegal issues. She's very experienced. She used to teach the Landlord Tenant Board Residential Tenancies Act course at the college to train new paralegals. So she knows the LTB inside and out, and she can answer those nuanced types of questions. But the other really big bang for your buck that you get with using this repayment plan page is this little clause that they kind of inserted in the fine print at the bottom of your repayment plan paperwork. And that basically says that if the tenant actually does agree to the repayment plan, if they initial saying, yep, this repayment plan sounds reasonable, and then they don't pay it, you don't have to go to a hearing to evict them. Right? So this is like the biggest thing to happen to the LTB since sliced bread, right? It's like you don't actually have to wait your 8 months for a hearing to have your tenant say, yeah, I can't pay rent and now I want a payment plan and I'm still not going to pay rent, and then you get another hearing and then you can evict them. So if you're reasonable with your tenant and you say, hey, like you're behind a month or two, how about you pay me an extra $200 a month and catch up, and then next month they don't pay their rent again, you can apply straight to the Landlord Tenant Board for essentially as fast as immediate gets for the LTB land for an eviction. So you can essentially, you don't have to wait for a hearing. There's no hearing that gets scheduled. You can apply, you submit your repayment plan paperwork. You say, yep, the tenant is initial, they've agreed to the repayment plan. You show that they have not actually followed up with the repayment plan. They have not met their obligations under this voluntary agreement. And you can get an order for an eviction. Right? Yes?
Does that mean the smaller amounts you put in the payment plan would encourage them to sign quicker and encourage and possibly maybe so you can get the person faster?
Yeah, possibly. So the question was like, how reasonable can you make it, right? If you put really small increments, yeah, if you say, hey, you owe me rent plus $50 and in 3 years you'll catch up on your rent, it may be a really good way for your tenant to sign saying, yeah, that's unreasonable, I'll pay an extra $50 a month, because they may not pay rent anyway. Like they're a tenant that's just going to sign anything and then not pay rent again the next month. So yeah, this is kind of one of those really nice tools that you can use to be a good landlord, that people fall on hard times, sometimes they need a little help, sometimes tenants really do honor their repayment plans and pay you back, which is a great thing to have, right? No one wants to have to evict their tenant if they're getting rent. So it's a really good tool that's, again, really underutilized, that use the repayment plan, but get it in writing, right? Don't have your tenant be like, yeah, I'll pay you next month or whatever. Like, put everything in writing, initial it, sign it, have them initial it, get all your paperwork lined up so that if your tenant doesn't pay rent, it's the fastest eviction you can possibly get under kind of current legislation and LTB standards, right? It's not a completely slam dunk. There's the option that, the tenant can file, for a stay. But unless you have a very savvy tenant who really knows the ins and outs, or maybe has help from something like a Kinawea lawyer, it's as close as you can get to the fastest possible eviction, like imaginable under current scenarios.
You probably know you're answering the faster because it says tenant if you read this term initial here.
Yeah.
If you don't initial, there you go.
Yeah, that's right. So that's kind of one of those things that the repayment plan is voluntary. So you can't require your tenant to agree to your repayment plan. So if you offer the tenant the repayment plan and the tenant says no, that's kind of further evidence when you eventually get your hearing saying, you tried your best, you already offered them a payment plan, you don't need the court to offer them another payment plan, here's your evidence of your repayment plan, and here's your tenant's non-initial, essentially saying they refuse to agree to it, so don't give them another chance, right? If they do sign it, if they do initial, because it is voluntary, then you get the opportunity to say, yeah, the tenant agreed, they initialed, this was not, I didn't coerce them into it, they voluntarily agreed to the repayment plan, and now they're not paying the voluntary repayment plan that I so generously offered them as a landlord that I didn't technically have to do anyway, even though everyone should. So again, there's a lot of the kind of hoops you have to jump through the LTB, But this is let's say it's an underutilized hoop, that if you do this hoop properly, you can get the fastest eviction possible because you don't actually have to wait for a hearing date. It's just a straight order. All right, a couple of last extras to go over. So some of the new things with Bill 184, which was the last piece of legislation, is you can now claim for arrears, damages, and even unpaid utilities up to a year after the tenant left. Right? So before, you could claim things, but as soon as the tenant left your unit, you had to go to small claims court. Right? Like basically the LTB said, nope, they're not your tenant anymore, doesn't apply, go to small claims court, not my problem. Now the LTB will accept these cases up to a year after your tenant's actually already left. So if you have one of those tenants that likes to skip out on their last water bill, right, or on the last month's rent, to be like, I'm out of here anyway, what do I need to pay the last month, the kind of second to last month's rent for, you can actually go after them even though they're no longer living in the unit and get your court order for payment. Right? If they're still living there, then you'll get your payment plus the eviction, hopefully, but you can at least get the court order for payment, and then you can follow up yourself or take that to a collections agency and have a legal court order for payment even though they're no longer living in the unit. One word of warning. So bad faith N12s. So N12s is when the form you fill out saying you're going to move into the unit for personal reasons, right? Either you're going to live there or a family member is going to live in the unit. So this is kind of one of the more straightforward ones to evict a tenant if you're actually using it for personal purposes. Right? So this often happens on the sale of a property, where it's a landlord situation, they sell their house and like a new family is moving in, right? So there's a lot of N12s that happen in real estate normally. But there's also been a lot of abuses of the N12 as kind of a sideways way to say, yeah, tenants, like I'm selling the house, like, or I want to move in myself, like, get out of here. You have no recourse under the N12, right? It's not something you kind of like appeal. It's just an N12 when you're gone. And a lot of landlords have tried to use this to kind of essentially illegally evict their tenants. So one of the things the Residential Tenancies Act now further cracks down on is the penalties for this have gotten multiple times harsher. Right? So this is less an issue in a city like Thunder Bay, but it's happened a lot more in cities like Toronto, where the rents are going up like nuts, and landlords will do whatever they can to evict people. So now, for an individual, you can get a $50,000 fine for one bad N12. Right? One N12 that you kind of wanted to work in a gray area, and you thought, I'll squeak it through. Maybe I'll live in the unit for like a month, and then I happen to not live there anymore. That's now subject to a $50,000 fine. If you're a corporation. Right, so if you've incorporated a business and have bought rental properties under a corporate name, that corporation can be subject to a $250,000 fine. And this isn't like perennial offenders, like I've done this 12 times and finally I'm getting cracked down. You're eligible for these fines on your first offense. Right? So like, I made a mistake, it was a bad N12, it can be a $50,000 or $250,000 fine. So don't do bad N12s. It's kind of the moral of the story there. Right? And one of the rules with N12s to consider is that for an N12 to be kind of proper, the unit can't really be on the market for an entire year. So if you move into the unit and then 4 months later you move out of the unit and all of a sudden it's on the market again, it could still be considered a bad faith N12. So legally, the unit essentially has to be in your kind of personal possession or personal family member's use for a year, and only after a year can you kind of reconvert it into a public, publicly marketed rental. So just be really careful about the N12s. Lastly, another win for landlords on this one is that if you've ever been to a landlord-tenant board hearing and you've had what's called in the language a trial by ambush. So this is essentially where you go to the hearing that you say, hey, my tenant hasn't paid me rent in 3 months. And then all of a sudden the tenant remembers that, I asked you for that maintenance repair and you didn't do that. Or, there was a rat problem that I never reported that happens to come up at the LTB now because I'm, getting evicted. And so, adjudicator, please feel bad for me because apparently there's been rats in my units even though I never told anyone about it. So this is one change to the legislation that happened that says tenants can only raise issues if they've given notice about it prior to the hearing. So essentially when the tenant gets notice that, hey, you're being evicted for not paying rent, they have the opportunity to essentially say, well, here's my issues with the landlord, and they can kind of like counterfile as part of the case. So that's legit, right? If you've been a bad landlord and the tenant is not paying rent because the buildings fall apart and there's rats and the ceiling is caved in and whatever, I mean, they should still be paying rent legally, but sometimes there's maybe better or worse reasons not to pay rent. Tenants are not legally allowed to bring that up unless they've actually raised it as an issue prior to the hearing. So that's just an opportunity, again, to address the thing that's on the table at the hearing. And so tenants can't just bring things forward that legitimate or not legitimate were never talked about before. So that's kind of something that protects you a little bit. You at least know what you're walking into, and you don't get ambushed at the hearing where all of a sudden they're saying, hey, I submitted a maintenance request 3 months ago, and I want that dealt with now before I start paying rent. Okay, so that's basically the end of the zoning and the LCB review. I just want to give you guys a little bit of a sneak peek to what Rent Panda is up to next. So the next product that we're launching is happening basically this weekish, which you all got cards for. So you got discount codes that basically give you free access to the new screening tool that we're building. And this we like to call essentially a screening tool on steroids. So it's the most thorough, or if you will, the most invasive possible tenant screening that you can imagine, that really gives you everything you could possibly want to know about your tenant that we can legally acquire. So this will be dropping this week, and essentially what it is it functions right now a little bit outside of the kind of traditional Rent Panda platform that you're used to. You'll see some new buttons pop up on the website where you can screen a tenant directly from anywhere. So if you do have a tenant that comes from Kijiji or from Facebook or in other parts of the province where the Rent Panda website isn't as popular, where we have our tools launched, you can screen people directly from there. So it's a complete, extremely thorough application form that you can send out initially. And then once they complete their basic application form, then you can do the same kind of credit checks you're used to, the criminal background checks, but also with some new really enhanced features. So we can actually verify their identity. So we can prove that they are who they say they are through government-sourced ID. And we can also do bank checks. So this is the income and expenses verification. So this actually goes into the tenant's bank account. Software scans all of their incoming revenues and expenses, and essentially it builds a report saying, here's the regular patterns of when they get paid, and here's the regular expenses they have. So you actually get a breakdown of can they actually afford rent, right? Like what everyone wants to know is like, sure, like you make X amount of dollars, but how much is your car loan? How much are you spending on cat food? How much are you spending on going partying? This actually scans the tenant's bank account and compiles a report of everything that they spend, all the money that they come in, and says how much can they actually afford to pay in rent. So it's an extremely powerful tool that we partner with another company to provide that gives you a really in-depth assessment. There's also verified landlord references. So we found this a bunch through our property management company and our leasing agent divisions that a lot of times tenants will just fake references, right? They'd be like, yeah, it's my friend down the street who's my landlord, and they happen to be like my cousin. And were they really my landlord, or were they really just like a friend doing me a favor saying they're my landlord? Like, who knows? So through this new tool we have, we can actually verify that the person that they claim to be their reference is their reference. So you know that you're getting real references, right? Because a reference from a landlord saying, yep, they paid their rent on time for the last 2 years, no damage, that's worth a lot. A reference from their cousin saying they paid rent on time, that they didn't do damage, it isn't really worth anything. So it's important to actually verify that people are who they say they are, especially when you're just doing a phone call. So this new tool can do that. We also have personalized videos. So a lot of times you're renting to people out of town, or you want to screen people ahead of time. So this allows tenants to actually record a video of themselves, kind of talking about themselves or explaining why they like your unit, and you can watch that prior to even offering them a showing. So you can get a sense of who they are, what they're up to. You get the kind of like vibe factor. Are they a real big sketchball that's kind of high on the video, right? Or are they like a reasonable person that can string a sentence together that sounds like someone who you actually want to meet? So personalized videos are a part of it. And then the really neat part is our recommendation algorithm. So we essentially take all the information that's processed through the application form and all of the screening tools, and then we rank them for you. So for the truly time-sensitive landlord who doesn't want to look through 50 different applications and read through 50 different credit scores and where everyone works and where everyone lives, this algorithm will essentially take all that information and then rank the tenants for you. Say, yep, here's your top 3. Here's how they score on all the top metrics. And then you can basically just bother with those top 3. You can say, yeah, I like the recommendations that they gave. We'll show you everyone who applied, but automatically your best ones will pop to the top. And then you only have to spend your time dealing with the best applicants, right? You don't have to sit there for hours kind of scrolling through information, responding to those Facebook messages, right? Is it available? It's kind of like, I hate Facebook just for putting in that button. You don't have to deal with that anymore. You can essentially just use our new software and algorithm, and it'll be like, yep, here's all the information, and here's the top ones. Don't talk to anybody else. All right, so that's roughly it for this evening. We'll kind of open it up to Q&A, but I just